Hi, and welcome back to Chapter 2 in your commercial law course. Chapter 2 is still working on contract basis. We're going to talk about an overview of the common law as it relates to contracts today. At the end of this chapter, you should be able to understand the legal terms used in the contracting process, recognize the general elements of a contract, describe the different classifications of contracts, understand the concepts of quasi-contract and unjust enrichment, and distinguish between a void, voidable, and an unenforceable contract. Before we get too far into this, I do want to bring your attention to an element of our textbooks that are at the beginning of every chapter. It's a little thing called Just Suppose, and it gives you a fact scenario that will help you to understand the things we're going to study in that chapter. The one for this chapter is particularly good. I commend each of the chapter's Just Suppose sections to you. It's a good idea to read those up front and then refer back to them as you move throughout the chapter to check your understanding. Remember, in Chapter 1 we talked a little bit about the ubiquitous nature of contracts and how they really invade every area of our daily lives, sometimes even without us knowing it. We also talked about the difference between contracts which we interpret with regards to common law and those that the UCC applies to. Today we're mainly going to be concentrating on the common law definitions of contracts. And as we get started here, it's really important for you to understand the basic definition of a contract. In its simplest form, a contract is an agreement between parties for value which is legally enforceable. And that last concept there, legally enforceable, is something that we're going to talk a lot about throughout this semester. Because simply stated, a contract is an agreement that the law will enforce. And so the study of contract is determining whether or not the elements are present for a contract to be enforceable. And when you start looking at a contract, there's a few questions you should always ask yourself. Number one, did the parties have an agreement? What is the subject of that agreement? What are the rights and obligations that are created under the agreement, if any? Did the parties perform those rights and obligations? If the answer to those questions is yes, you probably have a contract. If the answer is no, you have to figure out what the consequences are. And so in its basic form, as you can see on the slide, a contract is an agreement between parties for value that's legally enforceable. And that's what the court is going to look for if you end up having the unfortunate situation where you go to court to enforce a contract. Okay, you know there's no way around it. In every class we have to learn the jargon. When we're talking about contracts, one thing you should know is K. The letter K is shorthand for contract. You may see that in documents going back and forth between you and the attorney. Parties to a lawsuit, you can use the letter P or the Greek alphabet letter pi, and defendant is either D or the Greek alphabet letter delta. When we're talking about the beginnings of a contract, we deal with a promisor or a promisee. The person who makes a promise is the promisor. The person to whom the promise is made is the promisee. Same thing with offeror and offeree. The offeror is the person making the offer. The offeree is the person to whom the offer is made. Let's look at some more terminology as far as the components of a contract. And these are things that we're going to be looking at. Each one of these terms we're going to be looking at chapter by chapter. These are actually the titles of some of our chapters as we go forward. Offer is the initial communication, comes from the offeror. Acceptance is what we hope to get in response as an offeror. Consideration is the value that goes along with a contract, and that's an important concept. We're going to spend a lot of time in about chapter 4 or 5 on that. Mutual assent is an agreement on the terms, and you'll see the term mutual there. That's a very important part of this terminology. Mutual means both, right? Capacity is the legal ability. When we talk about capacity, we talk about an age limit. People above 18 have capacity. People under the age of 18 may not have capacity. There's also mental capacity. Legality deals with the subject matter and purpose of a contract, whether or not the contract is for some legal purpose. And finally, a legal form. We'll see in some cases that the law requires some contracts be in writing. Some, not all, but some contracts be in writing. So those are the basic components of a contract, and again we're going to study each one of these chapter by chapter throughout the rest of the semester. Another important way to interpret contract is based on classifications. And contracts are classified in a variety of ways. Some are based on the method of formation, and others focus on the legal effect of the contract. And the contracts we're going to discuss in this section are not mutually exclusive, meaning you can have a bilateral express contract. You can have a bilateral express fully executed contract. So the fact that we're saying it's not mutually exclusive means that just because it's bilateral doesn't mean it can't be express or implied also. So the first way we classify contracts is either bilateral or unilateral. Bilateral contract is probably the most common type of contract. It's the one that most people think of when they think contract. And essentially this is a promise made in exchange for a promise. The important thing to note here is it's almost immediately binding. If I promise to do something, you promise to do something in return, the moment those two things happen, we have a binding contract. As an example, there's one given in your book, example 1. Miss Matthews asks Mr. Dale, will you come and paint my garage tomorrow for $200? Mr. Dale replies, yes, I will paint your garage tomorrow for $200. So a promise, I'll pay you $200, in exchange for another promise, I will paint your garage tomorrow for $200, creates an immediately binding bilateral contract. Now let's contrast that with a unilateral contract, which is a promise in exchange for performance. What's important here is the binding nature of the contract doesn't arise until performance starts. So in this case, a unilateral contract, rather than be an exchange of promises, is where only one party makes a promise and the other party is required to do some act in return. In a unilateral contract, the act of performing is the acceptance of the contract. So by way of example, we say, go back to our original example, say Miss Matthews asks Mr. Dale, will you come and paint my garage tomorrow for $200? Mr. Dale doesn't say anything back, but shows up tomorrow and begins to paint the garage. We have a promise in exchange for performance. At the moment that Mr. Dale begins to paint, he has then accepted, and we have a binding contract. Bilateral, promise for promise. Unilateral, promise for performance. Next classifications we're going to talk about are express versus implied. Express is one that is specifically stated. In other words, each party knows the terms and conditions of the contract. Can be oral, can be written. Doesn't have to be written to be express. Of course, we're going to talk about this throughout the semester. As legal professionals, we always want to reduce contracts to writing. But right now we're talking about enforcement and whether or not a contract has arisen. And we'll go back again to example 1 in your book. Example 1 is an express contract, right? Both parties understand the terms and conditions. One party will pay $200, the other party will paint the garage. It's express. The terms and conditions are known by both parties. Implied contracts are a little bit different. Implied contracts are created by the acts of the parties involved. Basically, you infer from the facts and circumstances surrounding the contractual transaction whether or not you have a contract, and behavior dictates the terms of the contract. 3 different types of implied contracts are implied in fact, implied in law, or sometimes called a quasi-contract, or quantum merit, or as much as deserved as a way to evaluate a contract. Now you may not quite understand this concept of implied contract, so I'll give you a common example. When you walk into a restaurant and you order something off the menu, you know that before you leave you have to pay, but the waiter doesn't ask you to pay for your food up front, right? You're sitting at the table, you're having a nice time, you order something off the menu, the waiter brings it to you, you eat it, and at the end of all that they bring you a check. There is an implied in fact contract when you order from the menu that at the end of the meal you're going to have to pay for it. Even though it wasn't said, the waiter doesn't say to you, hey, you're going to have to pay for that before you eat it. That would be rude, right? There is an implied in fact contract based on the acts of the parties. We know that getting food at the table requires us to pay for it at the end. So there's a simple example of an implied in fact contract. Implied in law contracts are a little bit different and usually come up in terms of unilateral contracts. I'll give you an example. Go all the way back to example 1 in your book now. One party asks for another party to paint the house, but the other party doesn't say anything, just shows up the next morning and starts painting. Well, in this situation, because the first part, the offeror, didn't hear back, she actually hired somebody else to paint the house, who will be there in about an hour. But the original offeree has already started painting the house. Now they're out some time, they're out some paint, they're out some labor, so they have expended something on their end, and the homeowner has actually gotten some benefit. So the law may say if we don't make the homeowner pay at least something, there's going to be an element of unjust enrichment. So we're going to use quantum merit, or provide the offeror as much as is deserved. If they use a quarter of a can of paint and they use 2 hours, maybe we put a value on that 2 hours and how much it costs for a quarter can of paint, and we require the homeowner to pay that to the painter. That would be an implied in law or quasi-contract. Okay, next classifications, executed versus executory. Now be careful with executed. There's two different definitions for executed. One, executed means it's been fully completed. The contract is fully completed. No further performance is necessary. The contract is fully executed. We also use the term executed, though, for a contract that's been signed. So don't get the two confused. Make sure you understand context. Executory, an executory contract is one which has not been fully performed by the parties. There are still some obligations left to be performed. If you want an example, think about a lease contract, a lease of an apartment or a house, right? It's a 12-month lease, and each month you have the responsibility to pay that lease payment. So 6 months into the lease, the contract has not been fully executed. It is in fact an executory contract because the parties still have 6 months worth of obligations to perform. Okay, a few more things to classify here. One, void versus voidable. These may be terms that you've heard. We talk about these in just about every area of the law. We're talking about regards to contract. If the contract is void, there never was a contract. There's never any legal effect. This is something that is for an illegal purpose, let's say, like a contract to murder someone is against the law. The subject matter of the contract is against the law, so therefore it is unenforceable. Remember, we talked about that enforceability element. You can't, if you hire somebody to murder someone for you, you can't go to a court and say, hey, Joe didn't kill the person I was asking them to, would you please enforce this contract, right? That's illegal. The court won't enforce it. Therefore, you don't have a contract. It is void on its face. Voidable contracts, on the other hand, may very well be enforced, and it's dependent upon another factor that we have to look at. For instance, are we dealing with a minor? Are we dealing with an intoxicated person or someone who's been adjudicated insane by a court? In other words, they didn't have the capacity to contract. So it may be an enforceable contract. We'll have to wait and see. We'll talk about that more later. It's not automatically void, but it may be voidable by the minor. It may be voidable by the person who has been adjudicated insane. It may be voidable by the person who was drunk at the time of the making, and so on. Okay, let's talk about unenforceable contracts. So unenforceable contracts are contracts that are otherwise valid, but something has happened between the time of the making of the contract and the time of performance of the contract that makes it unenforceable. For instance, if it is legal to sell widgets today and we make a contract to sell widgets, and before we deliver those widgets and the widgets are paid for, the legislature comes in and says, you know what, widgets are dangerous, we're going to make the sale of them illegal. Right? So it was enforceable and it was valid at the time it was made, but before performance it becomes illegal and therefore unenforceable. There are some other reasons contracts can become unenforceable. For instance, destruction of the subject matter between the time the contract is made and the contract is performed. The goods to be delivered or destroyed by fire. Right? The contract is then unenforceable with regards to those particular goods. Okay, final classification here: formal versus informal. The common law standard is for contracts to be in writing, witnesses required, transfer of real estates are an example of a time when we need a formal contract. The modern standard that we'll talk about more with regards to the UCC is that the focus is on the expression of the party's intent. So we have oral, written, implied contracts, much easier to enforce. Now, I don't mean to suggest that under common law you can't have an oral contract or an implied contract. I just mean that the formal common law elements is something that we more often see enforced under common law than we do under the modern standard UCC. Both of those things, like much we've talked about here, we're going to explain in greater detail throughout the semester. This chapter is again a broad overview of the elements of a contract, your introduction to contract law, and we'll come back in chapter 3. We'll start to really dig into some of these concepts. Hope you have a great day, and as always, contact me if you have any questions, comments, or concerns.